Hello and welcome back to On the Workbench. Today we're going to be talking about one of the most controversial retailers in the tool industry, and that's Harbor Freight Tools, love them or hate them, and their recent action in court. This should be fun. Hang on. So today we're going to be talking about two specific cases, one regarding perhaps what you might call misleading advertising regarding amount saved, and a second one regarding the design and perhaps patent infringement on a design of a specific floor jack. We'll talk about that when we get there, but first with the case that I'm going to refer to as the You Saved case. This is known as Jeffrey Beck versus Harbor Freight Tools, and it was certified as a class action. So in other words, anyone that's purchased from Harbor Freight Tools in the specific time period enumerated in this case is considered part of this class that's been affected by this lawsuit. And this lawsuit was effectively filed on your behalf to be able to seek relief in the form of the damages that were agreed to at the end as part of this settlement. And so at the core of this is the notion that the amount saved indicated on the receipt is perhaps an overestimation of the amount actually saved. In other words, the specific concern, the way it was worded in the agreement documents, was that the items were not sold at the higher reference price for at least 28 of the preceding 90 days. So in other words, a significant portion of the previous 3 months, roughly about a third of the previous 3 months, the item must be sold at the higher price that was referenced in the advertising to be able to say that you saved approximately so many dollars because of it being on discount or being on sale or otherwise noted in their marketing literature. You've probably seen that if you've looked at the Harbor Freight catalogs, you've seen the coupons, you see how Harbor Freight always tries to push to indicate how much money you saved by shopping at Harbor Freight. And so this lawsuit covers items purchased between April 8th, 2011 through December 15th, 2016. And so as part of the settlement, Harbor Freight, and I've got the language here on the screen out of the court document, goes out of its way to ensure that they are not admitting any form of guilt or liability, and the fact that they agreed to the settlement does not subject them to having made any admission of guilt, and that this can't be used or deemed as evidence for any purpose for anything in the future, the fact that they agreed to this. Presumably Harbor Freight agreed to this because they thought this would be a cheaper alternative than allowing this case to proceed farther on because of damages being sought for whatever monetary compensation and award for damage purposes that Harbor Freight thought might be out there. That's the principal reason why parties will settle in manners like this, and this also allows them to be able to put this clause into the document that we're settling, but we're not agreeing that we did anything wrong. So go along with the language there. Harbor Freight denies any wrongful conduct, blah, blah, blah. You can read that on the screen there. So in terms of the settlement and what this means for you, the Harbor Freight consumer or tool connoisseur that's purchased from Harbor Freight, that if you've saved your actual receipts and you have them in hand, you can actually receive 20% in cash or 30% back in Harbor Freight gift cards of the amount you saved that was listed near the bottom of the receipt. Now, this is not off the total, but this is off the supposed amount saved that the receipt was advertising to you. And again, you have to have the receipt, the actual receipts, to be eligible for 20% cash or 30% in Harbor Freight gift cards. Now, if you don't have the receipts, but your bank or credit card statements can be pulled up and identify purchases from Harbor Freight Tools, you can get 10% in cash or 12% back in Harbor Freight gift cards of the amount saved before. Now, you see the asterisk here. This does not include free items or items returned. Now, all other customers who are willing to certify under penalty of perjury and fill out the appropriate affidavit that can be found on the website I'll show you in a moment here, that they were affected by Harbor Freight's advertising, they can certify and receive a $10 Harbor Freight gift card by mail upon making the appropriate signature and legal declaration. So the documentation can be found at the website. I'll put this in the link to my video below at nationalpricesettlement.com. And so if you've been affected by Harbor Freight Tools and perhaps been misled, or however you feel about it, I want to be clear, just looking at the legal language, Harbor Freight did not admit any guilt, but if you felt that you've been affected by the advertising of Harbor Freight and would like to seek relief, or if you'd like to be able to opt out of the settlement class and to be able to pursue legal action on your own separately, make sure you check out this website to validate your or to exercise all of your legal rights as appropriate. So now moving on, our second case that we're going to talk about today is Snap-on, one of many folks' beloved tool companies based out of Wisconsin, famous for their truck delivery or truck service to job sites, principally auto mechanics. And Harbor Freight's been acting very aggressively in this area of trying to market towards mechanics, and they've came out with a new line of jacks recently that's in a bright yellow color, marketed under the brand name of Daytona. And they've got a 3-ton Super Duty floor jack that they're marketing as going head-to-head with the Snap-on FJ200 or FJ300 floor jacks. Here's a picture out of the Harbor Freight ad. You might have seen these floating around the circulars that you might have received in the mail, trying to pitch that these are really comparable products. Snap-on, however, has taken issue with this and has filed a lawsuit against Harbor Freight in the United States District Court of Eastern Wisconsin. Case number 16 CV 01265, filed September 21st of 2016, and the case has effectively come to a close as of January 4th of 2017. This case principally involves a patent design infringement screen there. So in the patent design in question, this was published or filed in 2014, published in 2015, and the claim is to an original design of a floor jack as shown and described. So let's look at the images from the patent, and here's the images of the patent of trying to indicate a low profile floor jack, and one of the key things are the wings on the floor jack and the claims made by Snap-on in the lawsuit, and this is just my highlights trying to summarize this for you. Now let me make this clear, this is out of the original filing. There was an amended filing later that added some additional details about lift cycles and performance that was added to this original complaint that causes these numbers that I'm going to show you to be slightly renumbered, but I'm just going to stick with these for the sake of clarity here from the original court filing when I started working on this video. And so the key filing, in my opinion, number 9, is that that Snap-on believes that purchasers, customers, and end users associated the shape, appearance, and non-functional features of the Snap-on jacks with Snap-on, including its reputation and goodwill. Bullet point number 10, Harbor Freight has manufactured, sells, offers for sale, and or imports or has imported into the United States garage floor jacks, including, but not limited to, the Daytona 3-ton Super Duty floor jack, DJ3000, collectively known as the Harbor Freight jacks. Harbor Freight jacks are substantially identical in shape and appearance to Snap-on jacks. We'll come back to see this bullet point 15 later. Bullet point number 30, the appearance of Snap-on jacks constitutes protectable trade dress pursuant to Section 43A of the Lanham Act. Claim 31, Harbor Freight jacks misappropriate, use, and appear substantially identical to the appearance and non-functional features of the Snap-on jacks. In other words, part of their trade dress. Claim number 35, Harbor Freight's actions have caused and continue to cause irreparable injury to Snap-on, and unless and until Harbor Freight's actions are enjoined by this court, Snap-on will continue to suffer irreparable injury because of Harbor Freight's actions. Snap-on has no adequate remedy at law. Claim number 42, Harbor Freight's acts are and continue to be willful and are undertaken with the intent to misappropriate and have been misappropriated the goodwill and reputation associated with Snap-on and Snap-on. And so in summary, the actions that Snap-on seeks from the court are number 1, or letter A, for Harbor Freight to stop importing and selling the products that infringe on their design patent. Relief B, for Harbor Freight to stop importing and selling products that infringe on Snap-on's trade dress. To pay damages, because of course we know this is going to be about money. And number 4, Snap-on would like to see this actually go to a trial by jury. But before it can go to a trial by jury, it had to go through a judge. And on January 7th, 2017, the judge issued her ruling. And just to read verbatim, in the present case, I conclude that Snap-on has not shown a likelihood of success under this standard. For this reason alone, Snap-on is not entitled to a preliminary injunction. I therefore do not address the remaining factors. And so at this point, the judge has effectively dismissed the case and thrown it out of court because the judge sees no likelihood that the legal burden of proof that Snap-on would have to prove could reasonably be met, or that Snap-on has any chance that a jury would be able to find in their favor. And so in the judge's ruling, there's a couple of very interesting parts here. Is that there's a nice table here of other jacks, and the upper left-hand corner is a Snap-on jack, and the lower right-hand corner is a Daytona jack from Harbor Freight. And then comparing the prior art relative to the design patent in question, you'll note the similarity between all these other jacks and their dates of patent, or at least their dates of sale, from whether it's Performance Tool, Pittsburgh, Mac Tools, Hein Warner, Jackco, and so on and so forth, that there's a number of jacks that look very similar, and that it would be difficult that an ordinary observer would be able to tell the difference between the any of the jacks shown on the screen based on whether it be trade dress, appearance, or anything else to that manner that would be legally relevant. And the judge's ruling continues that comparing the patented design with the accused design in accordance with the standards and claim construction stated above, I conclude that a jury is not likely to find that the accused design infringes. Although the two designs are similar, the overall effect of each design on the eye of the ordinary observer is different, such that an ordinary observer, taken into account the prior art, would not believe that the accused design to be the patented design. So a couple other notes from the ruling. Let's just keep on going through, and I'll put links below where you can find this information. To support its argument that the ordinary observer would be deceived by the Daytona design, Snap-on submits evidence of statements made by certain users of floor jacks. First, Snap-on submits an affidavit from one of its potential customers who states that he bought a Daytona rather than a Snap-on jack, and that he and his staff think the Daytona is visually identical to Snap-on jacks. So we've got a one-off statement here submitted to the court. Secondly, Snap-on submits an affidavit from some of its franchisees who state that their customers have told them that based solely on the visual similarities between Snap-on jacks and the Daytona, they believe the jacks must be the same. Third claim from Snap-on. Snap-on submits evidence of comments made on the internet websites suggesting that some commenters believe that the jacks are the same because they look similar. So then the judge's response to these three claims from Snap-on is as follows, the emphasis in there being mine. One problem with Snap-on's evidence concerning the visual similarities between its own jacks and the Daytona is that the evidence is primarily anecdotal and consists in large part of statements made either by biased witnesses, such as Snap-on franchisees, or by unidentified internet commenters. Indeed, for all the record reveals, the internet commenters who claim that the Daytona jack looks similar to the same Snap-on jacks could be Snap-on employees or franchisees. So I think this judge is pretty savvy to the internet and recognizes that the anonymity provided by the internet could mean, or at least doesn't remove the potential based on what was filed with the court, that the evidence submitted could be biased and is not impartial to indicate a truly representative sample of the public that would be able to provide a level of legal confusion provided to the general customer. So now a couple takeaways from what I think we've learned by looking at some of these cases. I think first of all, we've learned that Harbor Freight's marketing tactics has led to the class action lawsuit that we saw. Harbor Freight does indeed try to clone competitors' products, and this has not gone unnoticed by competitors, but at least for the Daytona floor jack, has been on the legal side. This is the only one I'm aware of that has come to court about a specific patent infringement or a competitor trying to stop Harbor Freight. But if anyone who's looked at Harbor Freight catalogs, you've probably have seen that their products often look remarkably similar to major brand name products, and they're more and more getting aggressive about trying to compare their products head on to major brand names and noting a significant price difference. No coincidence about that. Their marketing, though it led to a class action lawsuit, is was found to be generally legal. They admitted no guilt. Let me just add that caveat. They admitted no guilt, but they're definitely trying to toe the line between what they can and can't say in their marketing and trying to work things in their favor relative to the competition. It's also interesting to note that companies do watch internet comments and use them for their legal proceedings, as Snap-on tried to do with some internet comments that the judge rejected without the ability to verify that they were actually members of the public who might have been legitimately confused. And it's also interesting, the more we think about this, that this case regarding the amount you saved now clearly indicate that sales must not last longer than about 90 days, other than you'd be violating the 28 out of 90 days clause that was at the core of the you saved case. But one of the things I think was unclear to me is, how does this relate to any member discounts or reward or surprise offers that retailers are using these days? You know, I think of Sears with some of their surprise points, or even Harbor Freight that has their Inside Track Club, where if you pay a subscription fee each year, you can buy products at a cheaper price. It'll be interesting to see if this lawsuit has any encouragement towards plans like that, where it's not necessarily on sale, but you've got some other coupons, special points, or other details, such as being a member of some sort of program that affect the price. Again, I'm not sure how that legally plays in here, but to me it seems like that's a very reasonable observation that might come into play, and we might see more of that going down the road in the future. So if you've got any other thoughts or ideas, please leave them down below in the comments. I'd love to hear them. And I'm sure others on YouTube here would love to be able to learn from your comments. Thanks again for watching, and have a great day. Bye.